The most common defences to low-range PCA are unsafe reading. If you blow over the limit at a roadside breath test, you will then be taken to the police station or a booze bus for another breath test. It's called a breath analysis. Now, it's important to know that the evidence from the breath analysis machine is admissible in court, not the roadside breath test. However, it's also important to note that your blood alcohol concentration can increase for a significant period of time after you've been drinking, for up to 40 minutes, an hour, and sometimes even more. So this means that your blood alcohol concentration at the time when you drove may have been significantly lower than later when you were tested at the police station. If we feel this may be the case, then we can obtain a pharmacological report to show that the reading at the time of driving was likely much lower. Now, this can be sent to police, and we can request that the charge of low-range drink driving be dropped. If they refuse to do so, we can fight the case in court. A second defence is the 2-hour rule. It's important to know that police must test you at the police station within 2 hours of driving. Otherwise, the reading from the breath analysis machine is inadmissible in court. The third defence is called the home safely rule, and this simply means that police can't test you when you're on your own property. A fourth defence is called honest and reasonable mistake, and this is where you honestly believed that you are under the limit. However, it's important to note that that belief must be reasonable, and it may be applicable where you can show, for example, that your drink was spiked and you weren't aware that you were drunk or over the limit. Less common defences include necessity and duress. Duress is where you were forced to do something. Necessity is where you acted in response to an emergency situation.